Karen Read is facing increased opposition from the Commonwealth and from a couple of different sources.
Karen Read has been in the news left and right and all over the place this week. I'm Lainey Law.
And I'm attorney Andrew Myers.
And we have a lot of different updates happening in the Karen Read case, and some of them quite unexpected. So, Andrew, what do you have for us today?
Well, 3 months after Karen Read's trial ended in a mistrial, you would think that things would simmer down a little bit. Oh, no, not at all. We have the state ratcheting up its opposition. We have a surprise friend going to the Supreme Judicial Court for Karen Read. But why don't we start with the Supreme Judicial Court appeal? Several weeks prior to this episode, we took a look at Karen Read's actual memorandum in support of her appeal of the actions by the Norfolk County Superior Court. And we said, to be fair, when the Commonwealth released their pleadings, we would take a look at them. So that's what we're doing today. We're going to take a look at the Commonwealth's brief in support of their opposition to Karen Read's appeal.
Now, Andrew, just for our viewers at home, I want to stop you and ask, we have red paper.
Yeah, well, when you go to any appellate court, really, but in this case, the Massachusetts Supreme Judicial Court, the highest appeals court in Massachusetts, there are a lot of rules with respect to the font size, the margins, and a lot more. And if you don't follow them, they're going to, reject your appeal. So each side is assigned a color. Karen Read, the appellant, was assigned blue, and the Commonwealth, the appellee, is assigned red. So that's why we're looking at that. And this is their brief. They cite a ton of cases, a ton of rules, all in the index. But this is the crux of it right here. The jury in the Read trial reported 3 times in increasingly sharper terms that it was deadlocked. Now, that's the spin that was put on it by the appeal attorney. Its third and final note said that the jurors remained starkly divided over the charges and further deliberations would be futile. At no point did the jury express the prospect of unanimity on any charge, and the defendant argued at the time that the jurors were at an impasse and hopelessly deadlocked. Did the trial judge abuse her discretion in declaring a mistrial based on the deadlock reported by the jury? That's issue number 1. Issue number 2, you ask. The defendant did not object to the declaration of a mistrial. Now, again, this is the slant that's put on it by the Commonwealth. And in our episode on Karen Read's appeal, we pointed out that the camera panned awful quickly from Judge Beverly Cannoni reading the note. And she said it's a mistrial. And she didn't even give them an opportunity. But the Commonwealth is saying the judge found that defense counsel had multiple opportunities to raise any objection, and she explicitly found not credible the defendant's assertions that the mistrial was sudden and unexpected, or that defense counsel was not afforded an opportunity to be heard. Did the judge err in concluding the defendant consented to the mistrial? And number 3, the jury did not return, announce, and affirm any verdicts in open court. Was the defendant acquitted of the charges of second-degree murder and leaving the scene? To me, that's the number 1 issue. But, in fairness, I don't want to make too many comments until we get through all of this. And this is the statement of the case is something the Supreme Judicial Court requires. You just have to go through all of the background. And we've gone through all of this on our previous episodes. So if you want to go down into our details section, you'll see ad nauseum all of this background that I'm just kind of skimming past now because it's all been covered in previous episodes, right, Lainey?
Oh my goodness. I mean, all this and more, right? We've gotten into what feels like every single little detail, and I think this is a good representation of how far down you're scrolling right now, that this has been a big case and this has had a lot of issues going on with it from, oh my goodness, you can't even, well, now that we're here, but I was going to say is just like even things like the Aruba trip, it's just like there's so many details that are just all over the place and just make this so much more messy.
So here's the argument. We just went through how many pages? 20 pages of background, which our viewers know. Our viewers are really smart people. And I can tell that. I'm not just saying that. I read your comments. And so I know that most of our viewers are deep into the weeds of this case. And as I always say, the good stuff is in the footnotes. Never skip the footnotes. So again, this is the state saying Kearney does not deserve an appeal. And we're going to try this again on January 27th. Footnote 4, the Commonwealth addresses first the defendant's arguments concerning the mistrial before turning to the supposed acquittals. That was the order in which the issues arose before the trial judge. Moreover, the defendant attempts to use the purported juror statements in hindsight to challenge the necessity of a mistrial, even though those alleged statements were unknown to the judge and the parties at the time of the mistrial and could not have factored into the judge's exercise of her discretion. Well, she didn't ask. Oh, I said I wasn't going to comment. I said I wasn't going to comment. So that was uncalled for. And if you're watching from the Commonwealth, and I know there are some people that are, I apologize.
Better hope that you're never in Judge Beverly Known's courtroom.
Well, as I pointed out before, and I'm not bragging, I've tried cases in that same courtroom, that little teeny tiny courtroom that's maybe, it's bigger than our conference room here, but not much. The defendant was not acquitted of any charge because the jury did not return, announce, and affirm any open and public verdicts of the acquittal. Now, that's the crux of their argument right there. That requirement is not a mere formalism, ministerial act, or empty technicality. He must have gotten out his thesaurus, because he's really emphasizing the point that this was all behind the scenes. Damn, there I go commenting again. It is a fundamental safeguard that ensures no juror's position is mistaken, misrepresented, or coerced by other jurors. Boy, there goes the thesaurus again. It also protects each juror's right to rethink their position and to change their vote before reaching a final verdict. The alleged post-trial statements from certain purported jurors, that's A, B, C, D, and E, do not constitute acquittals, and the judge properly denied the defendant's request for a post-trial inquiry of the jurors. That inquiry would necessarily require delving into the jurors' deliberations, which this court has consistently and firmly held impermissible. Okay, so they go on to make that argument. Our review, the question for decision is whether the petitioner has shown an abuse of discretion by the trial judge in declaring the mistrial.
Some strong words.
Yeah, to their credit, the prosecution, the state of Massachusetts, does cite a lot of rules. They cite a lot of case law going up to the U.S. Supreme Court and down to the Massachusetts SJC. The issue is whether the judge abused her discretion, because that's the standard for reviewing what a judge does with regard to declaring the mistrial. Was there an abuse of discretion? So that's the standard, and they go through a lot here. And they have to. You're going into an appeal court and you're asking them to do or not to do something. So you'd better cite a lot of law, because if you just go in there and whistle Dixie, which I've seen some people do, you're not going to do so well. So after all of that, as discussed above, see, we really didn't need to read all that. As discussed above, defense counsel consistently sought a mistrial, and when it later transpired, raised no objection.
He wanted it.
Yeah, well, that's kind of out. Again, I promise not to comment, but that's kind of out of context, because the jury came back after some deliberation and said, we can't reach a verdict. And the judge correctly sent him back. But they're making a lot here of the statements that attorneys Jackson and Yannetti had made that, let's declare a mistrial. Let's, and those aren't their exact words, but the Commonwealth is making a lot of out of that. The jury returned its first note around noon on Friday, June 28th. Its second note on the following Monday, July 1st, around 10:45 a.m., and its third and final note around 2:30 p.m. that same day. This was Monday of the 4th of July week.
You're just further reminding us how much we don't want to be in that jury.
Really, really. I mean, it's Monday, July 1st, and the 4th of July on Thursday. My contention is people were thinking more about, wow, do we have enough hot dogs? Do we have enough buns? Oh, niece Sarah is allergic to, she can't eat gluten, so we got to go back out and buy more buns. And Aunt Mary, we have to go pick her up because she's, so that's what's on people's minds.
And they have them there for hours.
Really? Anyhow, counsel had 3 days between the first and second notes and several more. Oh, we have to get propane gas too, because that happens to me all the time. I run out of propane gas. And people are standing there waiting for their hot dogs and hamburgers. Oh, I got to run down to the store. I digress. Counsel had 3 days between the first and second notes and several more hours between the second and third notes to prepare for a possible mistrial and to discuss the matter with the defendant. Okay. This is a really important point that the Commonwealth is making. And to my mind, this is the crux of their argument. There's a concept in trial law that the most important things, and in appellate law too, are primacy and finality. So sometimes you make really important points at the beginning and you save something really important for the end, because that's when the jury and the judge are paying the most attention or can remember. So this is a key point in the Commonwealth's argument as far as I see it. The defendant was not acquitted of any charge where no verdicts of acquittal were returned, announced, and affirmed by the jurors in open court. As this court has explained in rejecting a claim of double jeopardy based on purported acquittals, the only verdict which can be received and regarded as a complete and valid verdict of a jury upon which a judgment can be rendered is an open and public verdict given in and assented to in open court as the unanimous act of the jury and affirmed and entered of record in the presence and under the sanction of the court.
We are one more COVID away from that being null and void. It's just like, obviously there's rules and there's reasons we follow the rules, but the world changes and, thankfully we're back in office now, but back in 2020, that couldn't even apply. So I think it's fair that things might change as technology improves.
The trial judge correctly, the Commonwealth says, ruled that the defendant was not acquitted of any charge. The requirement of an open and public verdict announced and affirmed in court is not a mere formalism. Public affirmation in open court provides safeguards against mistakes. The verdict must be affirmed in open court as the unanimous act of the jury and in presence of the whole panel. And in fairness to the Commonwealth, I said I would do my best to be fair and objective. I skipped over pages and pages and pages of law supporting their contention that it's a very formal but substantively formal requirement that the verdict be reached in open court. So what they're saying in all of this, that again, I'm skipping over, law school students, yes, download this motion or I should say this brief, and read it because it's really quite informative. It's good stuff. I wish I'd read this stuff before I went to law school. Would have been better than all those boring books they made me read. But anyhow.
You don't love every single one of the books behind you?
Well, let's put it this way. There's someone that I know in town who is an attorney, and they frequently post that they got a bad night's sleep. And I said, would you like me to lend you my law school contracts book to read? That'll put you right to sleep. Again, the defendant further argues that inquiry should be permitted here because double jeopardy is a fundamental constitutional right. And they're absolutely right about that. I shouldn't be making light of any of this because these arguments are based on solid law. In a well-known summary judgment case of Commonwealth versus Bederow, where it noted that if logic were to control, an inquiry could be made whenever bedrock constitutional rights are implicated. The exceptions would swallow the rule. I love that saying. Basically what they're saying there is, the jury's verdict is sacrosanct. That's the rule. You don't ask them questions. But there are some exceptions, and we've seen some of those exceptions, like in the Murdoch case and a couple of other cases that now see what juries do is being questioned. So what they're saying is that's the rule, okay, that you don't go into retrospectively the jury room, but there are exceptions. What the Commonwealth is saying here is the defense's arguments would allow so many exceptions they would swallow the rule. So for these reasons, the Commonwealth respectfully requests that this case be remanded to the county court for entry of a judgment denying the petition. Well, so anyhow, that's what they say.
It's fierce.
Yeah, and this has been expedited. The arguments are going to be in November before Thanksgiving, and this isn't the final word on the SJC appeal, because the defense, Karen Reed and her attorneys, will be allowed to file what's called a reply brief. So they filed the first brief, the Commonwealth filed its objection, and now the Karen Reed defense attorneys will file what's called a reply brief. So we're not done with this, and in fairness, we'll read that.
Yeah, it feels, I don't know. I mean, obviously, I feel like I'm a little bit biased when I give my opinion in this situation, but I feel like I've said this a million times before, where I feel like the reason of convicting someone and putting them in jail is, ideally to kind of teach them a lesson. I think, the fact that there's so much debate about this in the first place, the fact that the defense is saying, let's ask the jury, like, I don't think there's any reason not to, because then what's going to happen? Like, what if the jury says that they didn't come to an agreement? I think that with the access of technology, I think that things are a lot different right now. I think that, obviously rules are rules for a reason, but the rules were also made before we had cell phones.
Yeah, and what's really important here is that it's a constitutional fundamental principle that double jeopardy, trying somebody, you can't, if you're a prosecutor, you can't just try people over and over and over again and say, oh, gotta win. It's like playing pinball. You keep playing until you get a high score. No. Well, so let's take a look at a friend that came into the Supreme Judicial Court in Massachusetts. Literally, the American Civil Liberties Union has come in and filed what's called an Amicus Curiae brief. And I think most people know what that means. Amicus Curiae, there's very little Latin left in the law. There really is very little Latin, but this is some of it that's still there. Brief of Amicus Curiae, the American Civil Liberties Union of Massachusetts. Amicus Curiae means friend of the court. So the Boston chapter of Amicus Curiae, with the lawyers you see on the screen there, filed this brief. And, again, with the Supreme Court, you've got to list all the cases that you have cited. So when I skip through this quickly, because we're going to try and get to two other documents by the end here, know that they have cited case law supporting their position. And there it is. We're going through it. And again, this is available publicly. This is a public document. They've cited, constitution, statutes, and rules. But Andrew, get to it.
Well, and I think something that we should going into this is an organization that's here to support Karen Reed, correct?
Absolutely. And here, the American Civil Liberties Union of Massachusetts, that's why it says the ACLU, takes no position on what the evidence presented at trial or did not show. Rather, this brief addresses the trial court's decision not to respond to compelling evidence that there was a potential mistake or misunderstanding concerning the outcome of the jury deliberations and what processes will be employed by trial courts addressing any similar circumstances in the future. Defendant appellant Karen Reed faces the possibility of being retried on multiple criminal charges for which numerous jurors, A, B, C, D, and E, now claim they acquitted her. A retrial on acquitted charges would violate the prohibition against double jeopardy, a critical right enshrined in the Fifth Amendment to the United States Constitution and the Massachusetts common law. So far, so good. I think that sentence is irrefutable. No attorney can argue against that basic concept. Now, if the court does not grant appellants requested relief to dismiss or otherwise preclude the counts on the current record, then this court can and should prevent the potential for injustice by ordering the trial court to conduct an evidentiary hearing and determine whether the jury in her first trial agreed to acquit her on any count, such that it was not manifestly necessary for the trial court to declare a full mistrial. So what the ACLU in Massachusetts is saying is, yes, you've got to bring the jurors back and question them. Now, you should go to the court and file an Amicus Curiae brief and say, you can do it by Zoom. You can do it by, some other platform. You don't have to drag them in. But that's what they're saying. Yes, you should have an evidentiary hearing and bring the jurors in.
The whole thing is just crazy. I think, because the thing is, I just think about it like this, and it, obviously, people have their salaries no matter what, but it's just so expensive to go back into court where this could be something that you could be preventing spending hundreds of thousands of dollars potentially. By just calling, I think that
we all have these things. Doesn't everybody have one of these by now? I mean, even I have one.
And what if they call a jury? What if they contact the jury and the jury, says they couldn't reach an agreement? But then at least you did it. This is just basically ignoring everything, almost to be stubborn, it feels.
Right. So what they're saying is that at appellants, that's Karen Reed's first trial, the court declared a mistrial on all three counts after receiving notes indicating jurors were struggling to reach a unanimous verdict. But the court did so without polling the jurors to confirm they were deadlocked on all the counts, or even asking the parties whether they consented to a mistrial or wanted the jurors polled. The trial court erred in refusing to conduct an evidentiary hearing. The double jeopardy clause protects a defendant's fundamental right against successive prosecutions for the same offense. That right is deeply rooted in our country's history and legal system and has been vigorously enforced by both the United States Supreme Court and this court, the Massachusetts Supreme Judicial Court. To avoid improper successive prosecutions, the double jeopardy clause requires that courts carefully consider alternatives to declaring a mistrial and to make such a declaration only after finding a mistrial to be a manifest necessity. A failure to do so can bar reprosecution on double jeopardy grounds. The trial court had a clear path to avoid an erroneous mistrial, and we've been saying this ourselves. We should have written this brief. Simply ask the jurors to confirm whether a verdict had been reached on any count. Asking those questions before declaring a mistrial is permitted, even encouraged by Massachusetts rules. Such polling serves to ensure a jury's views are accurately conveyed to the court, the parties, and the community, and that defendants' related trial rights are secure. So now we're talking about a trial that went for 2.5 months. It started April 15th for the jury selection and didn't end until July 1st, as we mentioned before. So how long, after that long of a trial, how long would it have taken them to just, poll the jury? Hey, guys, I mean, sure, there's 12 of them, but you asked 12 of them, each one on each three accounts. That's 36 people. But again, so what? After that long of a trial.
Especially considering how long they were doing deliberations for. They were in there for hours and hours and hours. It's going to take them less than an hour to get the answer from these people.
Well, that's what I'm saying. I mean, some of the testimony just was excruciating. It just went on and on, like the Sally Port just went on and on and on. And finally, people realized that it was flipped around. But so after all that, why not poll the jury? So let's keep moving, because again, I want to get to some other documents. I think we ended right here. This polling would have served to ensure a jury's views are accurately conveyed to the court, the parties, and the community, and that defendants' related trial rights are secure. It's also consistent with a nationwide practice of polling juries to ascertain verdicts, including before declaration of a mistrial. Well, we do things different here in Massachusetts.
Mm.
Here, a post-trial evidentiary hearing would serve the same purposes, enabling the trial court to determine whether the jurors had actually agreed to acquit appellant, that's Karen Reed, on counts 1 and or 3, such that it was not manifestly necessary for the court to declare a full mistrial. I thought that was very well written. Really
Yeah,
well.
it's just annoying to think about. It's just like, really, how long does it take to send out an email with a link to contact these people?
Not long. That's my answer.
It's just like, you could send an email in the morning, and by the end of the day, you'll have everybody.
So this is the ACLU's answer to the thing that the Commonwealth said in the previous document that we read. They're saying, well, the only verdict that's a valid verdict is verdict is read in open court by the foreman and on the public record, et cetera, et cetera, et cetera, and we have to follow the formalities. Well, their response to this is, hey, the prohibition against double jeopardy is a fundamental constitutional right that protects against the burden of multiple prosecutions. And again, they cite an awful lot of law in here, an awful lot of, we'd be here until midnight tonight reading it all. But, I just want to make the point that the statements that they make here are very well supported by United States Supreme Court law and Massachusetts Supreme Judicial Court law. And they kind of conclude this part of the argument by saying, finally, as relevant to this case, the double jeopardy clause can bar retrial even when the first trial ends in a mistrial with no acquittal or conviction. For even if the first trial is not completed, a second prosecution may be grossly unfair and burdensome to the defendant.
That's kind of what I feel and what I think with it. Obviously, like, we want there to be some type of repercussions to crime and doing stuff, but like, if the whole purpose is to make sure this doesn't happen again, after worldwide attention, I don't think she's going to go running around then hitting anybody ever again. If she did do it, which we can't really say one way or another, we don't know what the jury even said. And, obviously we all have our opinions based on what we saw in the court, but this is just a waste of resources. It feels like it just,
yeah. And also, your position is supported heavily by the United States Supreme Court. The statement that I just read and is highlighted on the screen there is supported by a lot of case law that was up above that I skimmed over, but also there are two, seminal United States Supreme Court rulings that our constitutional attorneys in the audience will acknowledge that, that statement is made with support. The decision to declare a mistrial without a defendant's consent is only justified by a high degree of necessity, again, United States Supreme Court case, and requires a scrupulous exercise of judicial discretion. I said I wasn't going to comment, so. Accordingly, when the government asserts the power to retry a defendant who has already gone through the burdens of one full 2.5-month trial, as is the case here, courts must safeguard the defendant's fundamental rights by carefully scrutinizing that assertion in light of all available information. I know I said the last thing was important, but this is important too. Trial courts regularly poll juries both after a verdict is announced and before a mistrial is declared. Remember, the state said, "Oh, we can't do that. It invades the province."
It's too complicated.
Yeah, it's complicated. We can't do that. In her motion to dismiss, Karen Reed asked for a post-verdict evidentiary hearing to determine whether the jury had agreed to acquit her on counts 1 and 3. The Commonwealth opposed this request as improper, and the trial court rejected it as prohibited. There we go with the thesaurus again. But the propriety and sometimes necessity of inquiring about the outcome of a jury's deliberations is confirmed by the fact that trial courts regularly poll juries on regularly polled juries. See that? I should have put that like in red. So the ACLU did a survey of cases that are similar to this, and they said trial courts regularly poll juries on verdict-related issues. Massachusetts courts frequently poll juries to determine whether the announced verdict was correct. Consistent with Massachusetts procedural rules, courts in this state and others also poll juries to determine whether deadlock exists or if future deliberation would be useful. There are times when a judge should use the discretion accorded by Massachusetts law to poll a jury after the verdict is returned. For example, in Commonwealth versus Nettis, the trial court properly conducted a poll of the jury when one juror indicated her disapproval of the announced verdict. As with the evidentiary hearings discussed above, the court's polling of juror votes did not impermissibly intrude into the jury's deliberative process. So in my mind, that says it all.
Mm-hmm. Well, and I'm wondering what the state is probably thinking right now, knowing that this is out there. Like, do you think that this is something that they should be scared about?
Well, I don't know. I said it in a previous episode, and it does bear repeating, that the Supreme Judicial Court is an appellate court, and they're very technically oriented, by law, by rule, by evidentiary mandates, and they really want to stick to formality. Like I said in the beginning, you asked me why was the cover red? Well, again, the cover, the font size, the margins, the fact you've got to do a table of cases, you have to do a table of rules, all that good stuff. So they're very technically oriented. And so, in my view, the Supreme Court is going to author a very well thought out analysis of the constitutional law and say, well, but the reason we have rules is to adhere to formality. And so I don't feel that the appeal is going to go anywhere. And I think that there will be a trial. Whether it happens on January 27th or not, I don't know. But as we're going to see in another document, if we get to it, and if my voice holds out, the Commonwealth is doubling down on its efforts to prosecute Karen Read. So let's finish this one up and we'll get to that one. And this is just a really important point that the ACLU is making, and that is that trial courts also routinely hold post-verdict evidentiary hearings to address irregularities in jury proceedings affecting constitutional rights. So again, they cite a lot of case law, Massachusetts and federal, in making that point. And then they triple down. The trial court should be compelled to conduct an evidentiary hearing given reports from jurors that the jury agreed appellant Karen Read was not guilty on counts 1 and 3, such that the court did not have the manifest necessity to declare a full mistrial. And they always say when you file a pleading or a motion, your goal is to move the court and tell them precisely what you want. So all of this legal argument we're going by here is very nice. It's very good. And I recommend that if you're really interested, you go ahead and read it. But they're telling the Supreme Judicial Court, for all of the foregoing reasons, this court should vacate the decision of the trial court denying Karen Read's motion to dismiss and remand for the trial court to conduct an evidentiary hearing if the charges are not otherwise disposed. So they're pretty clear. They're saying, hey, guys,
not cool.
Yeah, basically,
like dudes, email them.
They're saying, the declaration of a mistrial was too quick. They should have asked the defense attorneys. Other courts all over the country and in Massachusetts do, in fact, hold post-trial inquiries of the jurors. And 3, that's what we want you to do. After, all those many pages of constitutional law analysis, which are fine and they're solid, guys, send it back down to the Superior Court and have the jurors brought back. That's what I just summarized the whole thing in 3 sentences.
Yeah, so now I have a question because, obviously this is what Karen Read's defense was pushing for. Is this going to have any type of impact? Do you think now that they're coming out with this and supporting her, do you think that there is any chance that this might happen?
I don't know. And the reason
no
I say
magic
that,
ball.
The reason I say that, I don't have a crystal ball, but I mean, again, the Massachusetts Supreme Judicial Court likes to adhere to case precedent, even though the ACLU cited case precedent for bringing back the jury. But they like to adhere to the concept of finality and uniformity and reliability of what the courts do. In other words, if the courts say, A, B, or C, they don't want people coming in later and saying, no, it's 1, 2, or 3. They just don't like that. So But no, I don't have a crystal ball, and I can't know what they'll do. It does kind of tip the scales because you would expect Karen Reed's attorneys to support the position that they should bring the jurors back. You would expect the state to say no, 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 just like that scale over your shoulder there. No, no, no. That's our case law says no, you don't do that. So for another party to come in, the ACLU, a third neutral maybe party coming in, that tips the scales in my mind. And I think that their brief was very well written. I'm not a member of the ACLU, in case you're asking me. I'm not now or have I ever been a member. Sometimes I read some of their stuff and I think it's crazy. Sometimes I read some of their stuff and I think it's spot on, like in this case. So, it's a neutral third party that's coming in and telling the court, hey, here's what we think. We are an advocate nationwide for adhering to fundamental principles of constitutional law. We have a long history going back way before the 60s, but in the 60s, the civil rights movement. And so here's where we stand, and we think you should listen to us. And it was very well authored. But now there is something really rotten happening in this case. There's something really rotten. You've heard of Turtleboy, right?
Dun, dun, dun.
You know Turtleboy, right?
We know Turtleboy.
Aidan Kearney has been outspoken, whether you like him or not. He has done a lot of reporting on this case, and his factual reporting of things that have happened and not happened in this case are largely seen as what's blown this case up. I mean, sadly, there are M's everywhere, all over the place in 50 states. And sadly, people are convicted and people are wrongfully convicted, as we've talked about in other episodes. And these things just go by. They just pass by. I mean, there are cases all the time. There are cases being tried as we do this episode right now that nobody will ever hear of. So Aidan Kearney is largely credited for bringing this case to worldwide attention, really. Well, as you know, a lawsuit was brought against him by the Commonwealth of Massachusetts. And they are attacking him for, they claim, witness intimidation. His attorney is a guy by the name of Mark Bederow. He's from Framingham originally, but he now practices out of New York. And in Turtleboy's litigation, Commonwealth versus Aidan Kearney, just on October 17th, Attorney Bederow wrote, he's written some really interesting letters, and we should probably go back and read some of them, but this one kind of blew my mind, I guess I'll say. He wrote a letter to Robert Cosgrove, the Special Assistant District Attorney in the Norfolk County District Attorney's Office. It almost looks like he used an old typewriter, doesn't it?
Yeah, I was actually just thinking that.
Maybe it's just the scanner. I think it might just be the scanner. But anyhow, this is outrageous. Listen to this. Dear Mr. Cosgrove, a prosecutor, we are scheduled to appear in the Norfolk County Superior Court on December 2nd, 2024, to address issues related to the Commonwealth search of Aidan Kearney's cell phones. To date, the defense has not been provided with any data or extraction reports from Mr. Kearney's devices.
Sounds familiar.
Yeah. Wait till you see this, which have remained in the Commonwealth's possession since the Massachusetts State Police seized them on October 11th, 2023, a year ago.
Oh my God.
Over a year ago.
Now he has a new phone. I'd be so pissed. These things are like $1,000.
It gets worse. For approximately 1 year, the Commonwealth has claimed or implied that Mr. Kearney's cell phones have not been searched. These representations are patently false. Norfolk County District Attorney Michael Morrissey and Special Assistant District Attorney Kenneth Mello have known since October 23, a year ago, that MSP Detective Lieutenant Brian Tully, remember him from the Karen Reed case, searched Mr. Kearney's cell phones, and that the MSP extracted at least one of them prior to October 31st, 2023.
So they're just straight out saying, you guys lied to us. Like, we know that it was done.
Yeah. So they took the phone a year ago in October. They extracted the stuff, as you told us in a previous episode. They can do that right away, right? And they did it, but they're still saying, oh, yeah, we haven't done it yet. So...
yeah, I guess one of my things is like, because ultimately, like with the phone, I don't, I'm assuming that law enforcement has ways to easily circumvent like
Right.
passwords and stuff. But like really, like if I need anything from my phone, I just take a wire and I plug it into it. And granted, if I had someone else's phone, I wouldn't be able to know
Right,
their
right.
passcode or anything. But if I'm the police, presumably I'm plugging something into the phone that's just going to and bypassing everything,
Well, my understanding is that the FBI originally got this Celebrate software, but now it's available everywhere. The Massachusetts State Police have it. And there's other software too. I understand. I've spoken to people that say Celebrate was the first, but there are other softwares. But the point is, all that aside, they extracted Turtleboy's phone within days, if not weeks, of them seizing it a year ago, October of 2023. And they're still lying and saying, oh, we haven't done it yet.
Mm-hmm.
So this letter by Mark Bederow is really a mind blower. And this, by the way, this was posted to the Norfolk County Superior Court site. So this is public knowledge. We recently came into, because I know there's people out there, oh, we got private information. We have an exclusive. No. This is public information. It's out there. I downloaded it off the court website. We recently came into possession of several pages from a Celebrate extraction report of Mr. Kearney's cell phone, Exhibit A, and proof that it was searched by Detective Lieutenant Tully in October 2023, a year ago, during an investigation orchestrated by District Attorney Michael Morrissey into alleged witness intimidation of Chris Albert and Jennifer McCabe by a Stoughton court clerk and Mr. Kearney. It is outrageous that the defense obtained evidence in your actual possession related to alleged intimidation of named witnesses in the indictments against Mr. Kearney from a third party rather than from the Commonwealth, which is obligated to disclose this evidence to the defense several months ago, but instead has repeatedly denied its existence. Now, we've talked about this not only in this case, but in the Koberger case and some others. The Commonwealth or the state or the prosecution or the district attorney, whatever you want to call the prosecutors, they have an absolute requirement of disclosing exculpatory information. They absolutely have to. The Constitution requires it.
This whole thing, because it makes it sound like they intentionally knew that they extracted the data and then still just didn't want to hand the phone over for a year. So from what I'm gathering from this is that they contacted Celebrate or whatever and got it from them that they extracted the phone and got the data that they extracted. I feel like that's pretty damning if they're able to prove that.
They took the phone a year ago. They extracted the stuff within days, and they're still lying and saying, oh, we haven't done it yet. Come on.
I don't understand how that can fly, because also, like, think about if it was like the defense, like, in that situation for whatever reason. It's just like, why is the state getting a pass? Like, if this were an issue with the defense that they didn't hand something over, it's just like the state would be all over that. And now this is a situation where it's just like, it looks like the state was outright withholding information, and they're probably not going to get penalized for it.
To those out there, we get all kinds of comments, and I read all the comments. The dog wakes me up early in the morning because she's got to go out, and I better take her out, or there's going to be problems. So I wake up early. I can't get back to sleep. So I sit down and I read every comment. And the only reason I bring it up is because there are a lot of free Canada Read people that follow us, but there are a lot of people that follow us and say, oh, it's all BS. No, it's all made up. It's all, she did it. We know she did it. And so what's all this BS? And they use other terms. If anybody out there still thinks that it's all a smokescreen and that, it's all, the Commonwealth and the prosecution is all in the up and up, if this letter doesn't convince you otherwise, nothing will. Absolutely nothing will. So I just want to finish this up because, again, I have one more document I want to look at before the bell rings. District Attorney Michael Morrissey launched the investigation, which relied upon the Massachusetts State Police's search of Mr. Kearney's cell phones on September 29th, 2023, Exhibit B. And by the way, all the exhibits are attached. So when they say that this stuff is supported, it is supported. This was after he engaged Mr. Mello to handle any investigations involving Mr. Kearney due to a conflict that arose after Mr. Kearney's dogged reporting exposed information that persuaded a large segment of the public that the Norfolk County DA's office and MSP framed Karen Read for the murder of John O'Keefe, which almost overnight created the worldwide Free Karen Read movement. And it did. Okay, I'm sorry. Lest there be any doubt that Mr. Mello didn't know in October 2023 that Mr. Kearney's phones were searched and at least one extracted, his failed attempt to indict Karen Read and Mr. Kearney for conspiracy to commit witness intimidation shortly before Ms. Read's trial, in which Mr. Mello elicited testimony from Detective Lieutenant Tully that he searched Mr. Kearney's cell phones in October 2023, settles that question. We are deeply troubled by Mr. Mello's misleading representations, which have left the court and defense with the false impression that Mr. Kearney's devices have not been searched. Put simply, it is undeniable that the Commonwealth has failed to disclose any evidence from Mr. Kearney's devices, despite Mr. Mello's, D.L. Tully's, and D.A. Morrissey's knowledge for more than 1 year that such evidence has been in the Commonwealth's possession and that at least one of Mr. Kearney's cell phones has, in fact, been extracted. This is, I've got to read some more of this because it blew my mind when I read it. Mr. Mello has certified that his services as a special assistant district attorney incurred as of September 20th, 2023, Exhibit C. D.A. Morrissey officially authorized Mr. Mello's engagement on September 26, 2023, Exhibit D. Thus, D.A. Morrissey agreed and understood prior to September 29th, 2023, that Mr. Mello was the proper official to handle investigations related to Mr. Kearney's alleged intimidation of witnesses in the Read case. On September 28th, 2023, Chris Albert, a witness in the Read case and an alleged victim in the 2023 indictment, sought but was denied a protective order against Mr. Kearney before Judge Daniel O'Malley of the Stoughton District Court. This application was heard and decided in a courtroom open to the public. Later that day, Mr. Kearney published a blog about this matter. That evening, Jennifer McCabe, who was famous in the Read case, another witness in the Read case and an alleged victim in the 2023 indictment, complained in a text message to an unnamed individual, "I know it's late, but I'm horrified that Chris didn't get it. And I'm even more," she's horrified, "and I'm even more disgusted that for the second time, someone from the court leaked it right away to Turtleboy." Okay, so Ms. McCabe's horrified message was forwarded to D.A. Morrissey, who included it in an email he sent the following day to Stacy Fortes, who is the Chief Justice of the District Court, Thomas Ambrosino, Massachusetts Trial Court Administrator, Philip McHugh, Deputy Court Administrator, Judge O'Malley himself, the first Justice of the Stoughton District Court, and Lynn Bayland, Norfolk County First Assistant District Attorney, who I understand is retiring. District Attorney Morrissey used a personal email account. He's got a burner phone. D.A. Morrissey used, this is state business, right? This is a big case, right? This is a court matter, right?
I'm going to use casualemail@gmail.com.
He's using a personal email account to communicate with numerous high-ranking court officials, including the judge who denied Mr. Albert's application for a protective order, about official business he described as a matter of grave concern. Someone in the Stoughton District Court shared an affidavit that was prepared by a witness in the Commonwealth v. Read murder case with Mr. Kearney. Without elaboration, District Attorney Morrissey named court employee Michelle Littlefield as the leading suspect. He expressed concerns that the Read case witnesses had lost faith in the courts and that the actions erode the trust and integrity between the courts and the public and the relationship with the district attorney's office. We are extremely concerned that the improperly disseminated court material, unsolicited to a third party, which is continuing to cause harm and damage to a witness. See, he doesn't want anybody to know this stuff. You know, We also understand that Aidan, and they misspelled it wrong, but who am I to criticize anybody's spelling?
Nah.
We also understand that Aidan Kearney's had also immediately requested copies of the transcript record that was made on 9/28/23. Again, there is no way that he would have or should have known that a hearing took place. Exhibit B. DA Marr, we're getting to a really good part, so bear with me if you're tired of me reading this. We're getting to a really good part. DA Morrissey concluded by demanding that these matters be resolved immediately and that he would await your advice. After Mr. Kearney's October 11th, 2023 arrest, his cell phones were seized and maintained by Detective Lieutenant Tully. At approximately 9:15 a.m., the MSP obtained Mr. Kearney's passcode and gained access to them. So see, they got the stuff right away. They had it right away within 1 hour. Okay. After Mr. Kearney's October 11th, 2023 arrest, his cell phones were seized and maintained by Detective Lieutenant Tully. At approximately 9:15 a.m., the state police obtained Mr. Kearney's passcode and gained access to them. Within 1 hour, Ms. Peter sent a childish and harassing direct message on Twitter X to one of Ms. Reed's attorneys. We know you're involved in Aidan Kearney's little witness harassment game, and your texts with him have already been making the rounds. Buckle up, Buttercup.
This is unreal.
Ms. Peter, by the way, Miss Peter, we skipped over one of the footnotes in which she is identified as a source inside the Massachusetts State Police.
My God.
They took his phone early October 2023. They extracted the data immediately. Somebody is taunting Ms. Reed's attorneys. We know you're involved in a little witness harassment game, and your texts with him have already been making the rounds. So they've got all the information. They're sending these secret texts. A year later now, they're saying, oh, we don't have the information. We never extracted it.
The sending the text messages is crazy. I don't even know how that's permitted. I don't know if it is permitted or what. I think to be able to go onto someone's account and be sending messages is insane.
Well, you're supposed to have a warrant. They got certain warrants. But I mean, I heard Turtleboy on the radio the night before we are recording this podcast, because this letter was just made public. Well, actually, it's dated October 17th, so how could it have been made public before that? But there have been little dribs and drabs. But I hate the word bombshell. I hate that word. But this is a bombshell that they extracted the information off the phone a year ago, prior to our recording this podcast. They got it. Somebody inside the Massachusetts State Police was sending snarky little messages. I mean, I hate to characterize things, but it was a snarky little message taunting Reed's defense team. And now, officially, the Commonwealth is lying and saying, oh, we never extracted the information. Come on.
I don't understand, the idea that they're messaging, because the thing is just anybody watching this, imagine when somebody takes your phone and is going through your phone. Imagine the police take your phone and are sending messages off your phone. That is so disturbing.
And then they deny they did it.
And then they deny that it even happened.
So now, before we did this episode, I sat down and had a deep thought with myself, because these are courts that I practice in. These are courts. I'm a Massachusetts attorney, and these are courts that I have cases pending. And so I'm thinking to myself, I mean, am I going to face some kind of retribution? And I'm saying, I had a serious thought, but this is, again, I hate the word bombshell, but this is incredible stuff. There's something really rotten behind this case. The two cases. I don't care whether you're talking about the Karen Reed case or the case against Aidan Kearney, aka Turtleboy. There's something really deeply rotten behind this whole thing. And that one of the officers, got a hand slap that you're going to lose 5 vacation days. And another officer, what'd they do? They took him off 3 shifts. And it's just, there's something rotten behind this case. There's something really rotten behind the case. And, it is what it is.
Yeah, I mean, I say it mostly as a joke, but with partial truth, it's just to be concerned is just well, I guess I can never drive through Canton again. Not that the cops would know who we are. Just because we're posting on YouTube doesn't mean that it necessarily gets out there. But it's scary when you hear all these horror stories, and to think that these are real people in power.
And they haven't stopped. They are dead set on re-prosecuting Karen Reed, and they've ratcheted up the case. I mean, some in the comments, again, I read them all, and some of the comments have said, well, maybe this new prosecutor, Hank Brennan, will read all the documents and decide to dismiss the case. No, they're doubling down. They're tripling down. They are intensifying. I've talked to some people on the inside of the case who I'm not allowed to say who they are, but I've talked to some people on the inside of the case, and the people on the prosecution side are furious. Imagine taking a baseball bat to a hornet's nest. That's their feeling about the whole thing. They know, in their minds, they know Karen Reed did it. They think this whole FKR movement is crazy and wrong, and they've got to get, that's what I hear from the inside. But what we can show you that's public is from a discovery document that was filed. And this is the Commonwealth's notice of discovery. The Commonwealth has given certain discovery materials to the defendant. Now, this is what they did provide, okay? This is the Commonwealth in the Commonwealth v. Karen Reed case, and indicates, as of this date, the following discovery and materials have been provided to the defendant through defense counsel. Can you read that better now?
Mm-hmm.
Is that on the screen?
Yeah.
Okay. All right. So a lot of this stuff is just kind of perfunctory stuff, a letter from the police chief, although we don't have a copy of it, so we don't know exactly what it is. Whoops. How did that happen? All right. Look at this. Copy of curriculum vitae of Colleen Crawford, 3 pages. Copy of quick hash report of Colleen Crawford. There she is. Copy of extracted frames report of Colleen Crawford. So who's Colleen Crawford? She's a video extraction. She's a presentation person within the Canton Police Department. So look at this. Copy of extracted images from the extracted frames report by Colleen M. Crawford. So they're going back over all the evidence. They're going back over it. They're extracting additional frames from the SUV. They're extracting additional materials. And she's an expert in video and presentation. So God knows what she's going to come up with. So here we go. Disclosure number 11, copy of Canton Police Department Sallyport videos clarified. 1 flash drive. Remember, this was the video of the SUV that was inverted. I say backwards. I say it was something backwards. But anyhow, so now they're going to resubmit that, and who knows what the previous expert will have done to those videos in terms of enhancing it. Okay, so they're going to, 13 and 14, they're releasing the grand jury minutes, which is at least to the defendant. Look at this, number 15. Copy of updated Celebrite report of web history regarding Jennifer McCabe's phone. Now, remember, Jennifer McCabe was the one who had that controversial text or search, Haas long to die in the snow. And there was controversy as to whether it was done in the middle of the night around 2 o'clock or whether it was done around 6:35 or whenever they actually found John O'Keefe in the front yard. So they're going back into the phone. What, didn't they do it right the first time?
For real.
And then the dent moment is here. Judson Welcher. Copy of curriculum vitae. That's a fancy word for a resume, by the way. If you're applying for whatever job, you send them a resume, right? Quote unquote professionals like doctors, lawyers, PhDs, their resume is called a curriculum vitae. And here is Judson B. Welcher. Who is Judson B. Welcher? Judson B. Welcher is a biomechanics engineer and accident reconstructionist. So if you remember from the Karen Reed trial, Joseph Paul was their own accident reconstructionist, and he quite objectively did a horrible job. It really wasn't an accident reconstruction. He just kind of looked at the police report and he said that from what he saw, it was consistent with a side swipe. Now, to say that something is consistent with a side swipe, A, it's not beyond a reasonable doubt, which is the criminal standard, and also a side swipe is not backing into the person. Mm-hmm. So it appears that the Commonwealth now has retained a few new experts. This one, Judson B. Welcher, is a PhD and a biomechanical engineer and an accident reconstructionist. So there's the dent moment. And
surely if they do everything the same with different people, surely it'll work in their favor.
Well, so I think they were very embarrassed by the fact that the Reed attorneys had some, spot on great experts who weren't even paid for. So I'm just glossing over this. We've already done 3 documents in detail. We're just glossing over this. But if you want to see, a really good and thorough analysis of this document, this discovery document, our friend Alexis Room had done a really good, thorough episode on all. There's a lot in here, and it's signed by our friend, Special Assistant District Attorney Hank Brennan. So yeah, if you want a more thorough analysis of all the gems that are in here and the fact that the Commonwealth is really doubling down on this case, go over to Alexis Room. She did an entire episode, and she did a good job, I've got to say.
Judson has been employed in the field of biomechanical engineering and accident reconstruction for over 28 years. He specializes in trauma causation and prevention, human tolerance, restraint, design, instrumental testing with humans, and anthropomorphic test devices.
My closing thoughts are this case is ratcheting up. My guess is that the SJC, and I might be wrong, my crystal ball is not working properly. I'm guessing the SJC will say, no, good, nice try. You're right about you're absolutely right about the double jeopardy. It's a constitutional right. But here in Massachusetts, here, Mr. Jackson, this is how we do it. So there's going to be a trial. There's going to be trial 2.0. And the Commonwealth is going to be thinking about presenting this in a whole new way. Now, can't they be impeached and cross-examined? Because guys, prosecutors, that's not what you said the first time, is it? Yeah, that can happen. So those are my closing thoughts.
Yeah, I mean, at the end of the day, this all just sounds really messed up. At the end of the day, you want to feel safe in your community, and it just sounds like there's a lot of nonsense going on and a lot of inappropriate behavior by the police department. So it really makes you feel real bad about this overall. Obviously, this was never a good situation, but it just seems like the more that comes out, the worse and worse it looks for them.
Yeah, it's a case that keeps giving. It's a case that just goes on and on and on. And again, it's 3 months after the trial ended in a mistrial, and all this stuff is still going on behind the scenes. Both sides, are gearing up. And we will see what we will see. Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comment section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.